You're tuning into the Real Estate Diversification Podcast, hosted by trusted and experienced real estate attorneys who are also seasoned real estate investors themselves. Are you ready to explore unique real estate investing opportunities? Ready to learn about emerging trends and new ideas? Your hosts will help you understand the practical and legal complexities of a myriad of real estate investments so that you can maximize your potential and achieve financial freedom. Now, listen in and get ready to learn.
Welcome back, Red Podcast Nation. The topic of this podcast is key lease provisions in office leasing. The next provision of this lease was alterations, and also usually bundled with alterations, you see provisions about restoration. So the landlord may give the tenant the right to make changes to the premises during the term. Typically, the landlord wants to see plans. They want their expert to review it. There's usually a fee associated with the review. They don't want the tenant going in there and building some white elephant improvement that they are then going to have to take out at the end of the term at their own expense. Oftentimes, this is where the restoration obligation, oftentimes landlords will say that they will allow the tenant to make improvements conditioned on their right to demand the tenant restore the premises to the way it was prior to the alteration at the end of the term. Well, the tenant doesn't that gives the landlord maximum flexibility. The landlord can say, they can wait until the very end, and then they say, okay, we need you to tear that out. Well, the tenant would like to know in advance, and in fact, the tenant often would like to know that they don't have any obligation to tear out the improvements that they made. And so a reasonable compromise often is that the landlord can condition the alterations, approval of the alterations, on condition that they be restored, and they will tell the tenant at the time they approve the alterations, if they approve it, that it's conditioned on the restoration at the end of the term. That way everybody knows going in, when the alterations are done, what happens at the end of the term. When the landlord, it isn't just simply up to the landlord's whim, and the tenant can't simply build something that's uneconomic for the landlord that the landlord has to deal with after the lease term is over. Next provision in this lease was insurance. And you can tell that this was a tenant's lease, once again, because it had insurance obligations for the landlord. And that's unusual, because a landlord's lease doesn't make any mention of the landlord's insurance requirements. It only gives requirements for the tenant. It says, so typically in these insurance provisions, kind of what you would expect, it says you've got to have this much coverage. You can't have a deductible over this amount. And then the insurance company needs to be financially capable of paying out in the case that there's a claim, a casualty. And there's a guide for the insurance industry called the BEST guide, and it rates insurance companies on financial ability, and then or financial size and financial ability. It gives them a rating, and typically these requirements are expressed in the lease as the best guide rating. And so there's, like I say, there's one for size and there's one for credit worthiness. The landlord oftentimes will just want to say that it's up to the landlord, and the tenant has to meet whatever the landlord requires, and often say that the landlord can change the requirement as they go along. Well, once again, as tenant's standpoint, you don't want to be dependent on the landlord to make this determination, particularly when it can affect your costs. So the tenant really wants to have a determination going in, and if the landlord wants to change the requirements, say require more coverage at a later date, well, that can be done at renewal time, and that the lease can be modified through an amendment, and then the landlord will tell the tenant what they want. It becomes a whole negotiation. It's not just a one-sided thing. And then the flip side of that is the tenant just typically wants to be able to say, well, my insurance is what my insurance is. And this is what we have on our other locations. This is what we're going to have on this location, or at least this is what we're going to have in this location. Really don't want the landlord dictating the insurance requirements. And this is typically more important when the tenant is small or they're financially, I'm not going to say necessarily shaky, but they don't have deep pockets, lots of resources. The insurance becomes very important, right? Because if all the tenant's equipment catches fire, when the tenant doesn't have the money to replace the equipment, they're out of business. And if they're out of business, they're probably not going to continue to pay their rent. So the landlord wants to make sure that they have the adequate coverage. Same sort of thing actually is the tenant's concern, right? If the building catches on fire and the building burns down, and this is a very successful location for the tenant, they want to make sure that the landlord has the insurance to rebuild the building itself and all the improvements in it, so the tenant can go right back into the same location in the same building or a replacement building and continue operating their business. Provisions associated with that and the insurance, the tenant will typically, and this lease said that the insurance could be satisfied by a blanket policy, which means it covers more than one location. Oftentimes, when you see a landlord's lease, it has what's called a demand for a per location endorsement. And what that means is essentially the tenant has to have that amount of insurance that covers every location. So if it's $2 million and you have 10 locations, the tenant is actually charged with having $20 million worth of insurance, which may be a ridiculous amount of insurance, but also that protects the landlord because they know that if there are claims elsewhere, there's still going to be money to pay claims at this location. Two other terms that you often see in close proximity to the insurance provisions are casualty and condemnation provisions, waiver of subrogation, and indemnity. And typically you see all those clustered together. The casualty provision tells you who bears the risk of loss if there's damage. Typically when there's property damage, the waiver of subrogation comes into play. And the waiver of subrogation is sort of an inside term of art and something that non-lawyers and non-insurance people, it might not even rise to their level of awareness, but what a waiver of subrogation for property insurance says that in our example before, the building catches fire, the building burns down and destroys all the tenants' equipment, say computers and phones and so forth in there. Well, then each party's insurance company will bear the risk of loss. The landlord's insurance company will pay for the building. The tenant's insurance company will pay for the tenant's property, and neither insurance company will pursue the other. So it doesn't matter who was wrong. It doesn't matter whether the tenant's or it could be that the tenant's property caught fire and then burned down the landlord's building. In either case, each insurance company, if there's a mutual waiver of subrogation, and that each insurance company will then not pursue the other insurance company with a claim. And if you've ever been in an uninsured motorist accident where someone, or actually, if you've ever been in a situation where there's an insured party and you got in an automobile accident, your insurance company may pay you off and write you a check. And then what they will then do is they will turn around and pursue the other party to reimburse them for the money that they were out to pay to you. And so that's the concept of subrogation, right? Is that your claim against the other party becomes the insurance company's claim. That's called subrogation. In waiver of subrogation, it means the landlord or the landlord's insurance company or the tenant's insurance company, whichever the case is, has agreed not to pursue the other party and the other party's insurance company. So insurance companies typically aren't crazy about this because it's actually true insurance. They have to pay that claim and they don't have anybody else to come tag and say, okay, we paid this, you need to pay us. And then the, condemnation is if there's a taking by a governmental entity. So sometimes there'll be a road right of way widening, and part of the parking lot will be taken, or part of the building will be taken. Might even take part of the tenant's premises to accomplish setbacks or so forth. The condemnation clause typically says, who bears the risk of loss in that situation. And the government is the taking entity, is the source of the funds. The way I've always negotiated the condemnation language is whoever bears the risk of loss in the event of a casualty should also be the same party, or has the restoration duty in the event of a casualty, is the same party that should get the condemnation proceeds in the event of a taking. So if the landlord is responsible for restoring not only the building, but all of the alterations and so forth that the tenant has built inside the premises, if there's a fire or a tornado, then if they're bearing that loss, then they should get the insurance proceeds. So then it becomes an issue of fairness if the landlord then is not able to collect the condemnation funds if there's a condemnation. But often you'll see in tenants leases and landlords leases, people want their cake and eat it too. So they'll say, okay, in the event of a condemnation, I get the condemnation funds for my loss, but if there's a casualty, you have to restore it. And I usually tell the attorney on the other side, you can have one or the other, but you can't have both. Pick which one you want. Either you've got the duty to restore and you get the condemnation funds, or you don't have the duty to restore and you don't get the condemnation funds. And I usually leave it up to them. It's like, you pick. I think these are both remote possibilities. Condemnation is probably more remote than casualty, but typically my stance on that is that you can have one or the other, can't have both. And then oftentimes, along with the insurance, the casualty and condemnation language. And casualty and condemnation language. Usually, if the event that happens is significant enough, there's a termination right. And sometimes it's the landlord's termination right. Sometimes it's the tenant's termination right. Sometimes they both have a termination right. So let's say that the condemnor comes along and takes half of the tenant's premises, that the landlord's going to restore the building, but half of the tenant's premises are lost. In that case, typically the tenant would have a termination right, or at least would desire to have a termination right, because they were intending to operate in the entire space, not half of it. And then in a similar sort of scenario, only with casualty instead of condemnation, if there's a fire and it burns down half of the building, the landlord wants the right to terminate the lease. And often because it just may not make sense to rebuild the same type of structure in the same place and lease it to the same tenants. And typically the tenant will say, okay, you may have that right, but you've got to terminate the leases of all similarly situated tenants. You just can't pick and choose and decide to terminate my lease because I've got a favorable lease rate. Let's say you see these things clustered together. The last one of these that you see clustered together, but did not see clustered together in this particular lease that I was looking at the other day, is the indemnification provision. Indemnification provision is very inside the legal world. There are not a lot of people who understand it well, and not to speak ill of my fellow practitioners, but I've found some very seasoned lawyers that didn't really grasp indemnification. It's unusual because you can have a clause that reads exactly the same for the landlord and exactly the same for the tenant, and it's still no good for either party. Typically, when you see mirror image clauses, people look at those and they say, well, that's fair. That makes sense. I'm willing to accept that. There are many ways to get indemnification wrong. And I should tell you what indemnification means. Indemnification simply means hold the other party harmless. So what indemnification deals with is negligence and liability. And there's many ways to divide the responsibilities. A typical one says the landlord is responsible for everything outside the premises unless the tenant causes it. So an example would be the tenant does something in the common area that injures another party, and then the landlord is sued for that. In that case, the indemnification obligation would extend if, and we're saying that negligence is not in dispute, it's been established, perhaps it's even gone through a court case and the decision's been made. In that case, the tenant has to pay the cost of the landlord to make that injured party whole. And so the division there is geographic, right? If it's in the common area, it's the landlord's problem, whatever happens, and there may be, there may be an injury in there that the tenant had nothing to do with, but everyone in the building gets sued because their name is on the directory. In that case, it would be the landlord's obligation to indemnify the tenant because it didn't happen within the tenant's premises. If that's the breakdown, inside the premises, outside the premises. And so in that scenario, if something happened inside the tenant's premises and a party was injured, and it wasn't caused by the landlord. So you could have a scenario where the landlord has a workman inside the space doing repairs, and somehow they manage to injure a customer client of the tenant. Then in that case, the landlord would be responsible, but absent that scenario, then the tenant is simply responsible for anything that happens within inside the space. That's an equitable apportionment. There are many ways to do indemnification correctly, and there's probably just as many or more ways to do indemnification incorrectly. This is why, as I talked about in my first podcast, is that you need to assemble a team, and among the team needs to be your insurance agent and your attorney, so that they understand these provisions and make sure that you're protected. The attorney is going to make sure that the indemnification provision is fair, and your insurance agent is going to make sure that you have the coverage that you need to pay off any scenario that's likely to happen should some unfortunate event occur, in this case, with inside the premises. Next provision in this lease was assignment and subletting. So the tenant may decide, well, we would like to move on to a different space, and we know that we don't have a termination right. We can't get out of the lease. So what we want to do is assign this lease to another party. So they come in, they take over the space, they take over the rent payments, and we're off the hook. And we go on our merry way, and we either go to another location or just simply close this one up. And there is a distinction between assignment and sublet. And one of the ways that there's a distinction, a sublet would include a scenario where the tenant leases a portion of their space to another party. And in that case, that party doesn't have a relationship with the landlord. Their relationship is with the tenant. And so the tenant becomes a sub-landlord leasing the space to a subtenant. If you're a tenant, you want language that's as flexible as possible. You want to be able to sign to anyone. If you're operating a fashion store, you might want to be able to lease the space to, and this is in a retail context, but I'm not quickly coming up with a scenario in an office context, because office environments are typically pretty staid as long as everyone's observing the rules and regulations. But you might have a situation at retail space where you have a fashion tenant that's selling clothing and then decides to lease to a liquor store or a smoke shop or something that's less desirable than that. A landlord might not like that in their tenant mix. There's possible scenarios in an office scenario as well, but more likely it's not so much the use, as the use is going to be specified as office use in the lease. And but it's maybe the credit worthiness of the tenant or the credit history of the tenant. So if the landlord has a national tenant with good credit, and that national tenant then wants to assign or sublet the space to a tenant that's less credit worthy, than the landlord might very well have an objection. In this lease, tenant's form lease, it did have a consent provision. Typically in a tenant's lease, it's going to say that we have to get your consent, but it can't be unreasonably withheld or conditioned or delayed. And then also in this lease, there was a pre-approved assignment or sublet provision, and that was for a related entity. So if the business was part of a larger organization that had other subsidiaries or affiliate businesses, if the entity was controlled by, or under common control with the same company, then they would have the right to assign that at any time, just simply by giving the landlord notice. This is a provision that's it's not in every lease. Some landlords don't want to agree to sublet or assign or sublet to any tenant, and they always want it conditioned on their unrestricted approval or disapproval right. But when there is a pre-approved provision in a lease, this is the most common, that they can assign it to an affiliate business. Then we come to the default section of the lease. And then I have a good friend of mine who's a banker. He says, our loan documents, this much of the lease is about when everything goes right, or loan document, sorry, mortgage. This much of our document is when everything goes right, and this much of the document is when things go wrong. And it spells out what happens after things go wrong, typically meaning that the borrower does not pay. The default remedies are very important from the landlord standpoint, and there is a bit of negotiation that can go on in these. In this particular lease, once again, you can tell that it's a tenant lease, and one of the ways that you can tell is there's no what's called acceleration language. And acceleration language is like calling a mortgage note due and payable for default. So if someone doesn't pay their mortgage, the bank does not wait for 30 years or the 30th year of the loan before they sue the defaulting borrower for the money that they're owed. There's this acceleration clause that says, if you don't pay us timely or at all, then we can call the entire amount due and payable all in one lump sum today. You can have a similar provision in a lease. Landlords like an acceleration provision for the same reasons that lenders like an acceleration provision. Tenants, of course, dislike it for the same reason. And there are, in the default provision, there's other remedies. If there's a security deposit, landlord can cure any default that can be cured just simply with the payment of money, like making repairs. They can take that out of the security deposit, demand that the tenant replenish it. And then oftentimes they can terminate the lease. If they terminate the lease, oftentimes they have an acceleration right. Tenants typically try to fight that acceleration language. And then often at the landlord's option, the landlord can choose to relet the premises to a new tenant, never releasing the existing tenant, defaulting tenant. And then the tenant would be responsible for making up any shortfall every month. So you find a new tenant, but the new tenant can't pay as much as the defaulting tenant. And so the landlord still gets the benefit of their bargain. They get the entire rent, only the new tenant pays part of it and the old tenant pays whatever the difference is between the benefit of the bargain that the landlord had with the old tenant and what they can collect from the new tenant. In this lease, this isn't really one of the most important provisions in the lease, but I touch upon it because lots of folks don't understand it, including people in the legal profession. And it's called the quiet enjoyment clause. And it simply says in there, the tenant will basically be able to enjoy the premises during their term of occupancy, and they won't be disturbed in their occupancy. And what a lot of folks think this means is kind of common parlance of quiet enjoyment. Think, well, it's going to be quiet and I'm going to enjoy it here and no one's going to disturb me and life will be good and I won't have conflicts with the other tenants and so forth. That's not what That's not what the legal term of our quiet enjoyment means. Quiet enjoyment from a legal perspective, that means that there's not going to be another party that says, oh, I've already leased that space, or I've got a deal on that space, and I have the right to occupy it and you don't. So it's a totally different sort of thing than what you expect just from reading the provision. Oftentimes you can't tell that that's the import of that clause. So it's just something to impress your friends at cocktail parties when you can tell them about quiet enjoyment, and you learned it right here on the Red podcast. Next provision in this lease was about signs. And signs, of course, are probably much more important to the tenant than they are to the landlord. The landlord's probably kind of agnostic about signs, except to the extent that they create a cluttered appearance on the building. So the tenant large tenant, office tenant, typically will want sign rights on the exterior of the building. So if you travel down the interstate, you see a big office building. Often at the very top, there's the name of one tenant. And in some cases, you might see the name of two tenants up at the top of the building. Those typically are, if there's one, it's the largest occupant in the building. If there's two, it's the largest two occupants in the building. If it's a big building and there's lots of space on the facade of the building, two signs might not look that bad. However, if you've got a tenant that's paying a whole lot of money because they're occupying 3/4 of the building, and they get a sign, and the tenant that's occupying 10% of the building also gets a sign, you can create animosity between the landlord and that larger tenant. They're thinking, well, this was a big point of negotiation that I got this sign on here, and now it seems like, well, you're giving a sign to basically just anybody. And so it can be a ticklish subject, but that visibility is important to that office tenant. So it says that, and sometimes no one's allowed to have a sign on the exterior building. All of that is, like I say, it's something that's very important to the tenant. Sometimes the landlord will say, well, we're going to put up a directory in the lobby and that's it. Or we'll have a monument sign out in front of the building. Also, in some jurisdictions, you're not allowed to put signs on the exterior of the building. They like a nice, clean appearance. And so all that you'll have is either monument signage or directory signage, or maybe just one of the two, or at least maybe just directory signage. But like I say, it's an important consideration. This is something, like I say, it's more important to the tenants typically than it is, somewhat more important to the tenants than it is to the landlord. Then in this lease, once again, they have this tactic of where they buried a provision deep into the lease, and it's not where you would expect it, because we talked about repairs some time ago, and it appeared much earlier in this lease. And in this lease, and there was no mention of this, but earlier in the lease, but toward the end of the lease, there's what's called a tenant's self-help right. So that says if the landlord fails to make repairs, that the tenant can just do the repairs, bill the landlord for it, and then I think we did touch on this, but then the real hammer for that is that I went ahead and touched on it without it being actually the right place in the lease. But the tenant, the real hammer for that is that the tenant can offset the rent. So tenant goes out, fixes a hole in the roof, and tenant spends $10,000 and their rent is $1,000 a month. That means they don't pay rent for 10 months. And the landlord may be counting on that income and wasn't counting on the cost, but because the tenant was wise enough to negotiate this point, the landlord's waiting until the rent starts back up again. Once again, tenants like this provision, landlords fight it, and landlords who do a very good job of maintaining their property and taking care of it, they fight this type of provision because they don't know the quality, and then it can get into even deeper negotiations where it can only be approved contractors or a pre-approved list, or and so forth. Or tenant has the right to make the repairs, but tenant doesn't have the right to offset the rent. The tenant can send the landlord a bill. Of course, if you're the tenant, you don't like that because it's like, well, I paid this, and now I've asked you to pay me, and I don't know whether or not you're going to pay me back or when you're going to pay me back. So I like this offset rent remedy. We're getting down toward the end. One of the, and I have not covered exhibits. We'll do that here in just a second. But as I think I told you in the earlier podcast, or earlier in this podcast, this lease that I was looking at to prepare this presentation was 49 pages long. Most of that was lease, but a good substantial portion of it was exhibits. And these may be things that are not important and are not addressed for years, but it makes good sense to negotiate those up front rather than just simply having a clause that says, well, so-and-so will do X and so-and-so will do Y, and the form of the agreement isn't spelled out, or worse yet, one party has the right to say, we'll use our form on this and you'll just sign whatever it is that we send to you. Last provision, before some catch-all provisions at the very end of the lease that cover some basic things that we won't touch upon today. Landlord has the right to enter the property, access it. This lease, tenants form lease, said that the landlord would have this right, but that they could be escorted and that they would have to give 5 days prior notice. There was no difference between landlord access at the first day of the the first day of the lease or the last day of the lease. Obviously, if the tenant has announced or has either failed to renew or has announced their intention not to renew, landlord wants to begin to market that property as soon as they can. Oftentimes, the landlord in that last 6 months, so once the tenant has not exercised a renewal option, the landlord would want a right to put a sign up on the exterior of the building that says for lease. Well, if it's a single tenant building, it's going to be pretty obvious that this tenant is either going out of business, going someplace else, something's occurring. Oftentimes, the tenant has not told their employees 6 months in advance that this location is closing and that they will be working from a new location or perhaps no longer have a job. So there's some friction there. And so in this tenant's form lease, there was no mention of that. In a landlord's form lease, obviously they're going to want those rights at the end, and they're going to be different than the rights that they are during the beginning of the term of the lease. The last substantive provision in the lease that we're going to cover is the force majeure clause, and it's a French term. It means major force, and so this is talking about when the party's ability to perform is interrupted. There could be strikes, unanticipated weather, and just unanticipated circumstances. COVID. Through no fault of their own, either the landlord can't perform their obligations under the lease, they're prevented from it through, like I say, through no fault of their own, or usually the provision is reciprocal. The tenant also is excused from performance if they're prevented from it through no fault of their own. Typically, this does not extend to some things that are simply the payment of money. So the tenant can't say, well, we didn't make as much money as we thought we were going to make last month, and so we can't pay the rent this month, and I'm claiming force majeure because typically financial obligations, payment of money are excluded from force majeure. But it's just sort of a fundamental fairness. If it's circumstances beyond your control and you would otherwise have the ability to perform, or you even have the desire perhaps to perform but can't, the landlord should not have all of those default remedies, or vice versa. And in this lease, something was really unusual about this is that in certain default situations, the tenant had the right to terminate the lease, which you almost never see in a commercial lease. It's highly unusual. Tenant usually has to have a very strong upper hand to be able to get a tenant termination right for a landlord default. Okay, now, well, I'll just go through a list of what the exhibits were. There was a construction exhibit, which talks about the initial improvements that are going to be built in the space. And if the landlord construct those or tenant construct those, and that will all be spelled out in the construction exhibit. There was a memorandum, which talks about the start date. Typically it gets exchanged when the rent commences, and it'll say, this is when the lease commences, this is what the rent commences, when the rent commences, this is what the rent amount is, this is when the lease expires, so forth. Sometimes that one of the parties will want to record that, and that's a point of negotiation. Landlords often don't like memorandums to be recorded because tenants fail to clear those from the records and sign a release so that those are no longer records. So it looks like the tenant still has an attachment or a right to occupy the space, and they've actually moved on. And a new tenant coming in might do an investigation and say, and we can't lease this space because you've already leased it to this other tenant. Then there is an estoppel certificate. And an estoppel certificate is just a snapshot in time, and either party can typically request that. And it's very similar to the memo in the beginning. It says, these are the parties, this is the rent, this is the length of the term. The tenant has not prepaid rent. The landlord is not in any kind of a default. Typically, lenders want to see this sort of thing in a refinancing situation for the owner. Tenants may request it. It's typically not as important to the tenant as it is to the landlord or landlord's lender. Then there was, in this lease, there was a document called a non-disturbance agreement. And oftentimes you'll see this as a subordination and non-disturbance agreement. The non-disturbance agreement just simply said, if the landlord defaults on the loan and the property is foreclosed, the tenant will not be evicted, or the lease will not be terminated. Actually, the lease will not be terminated because of the foreclosure, so long as the tenant's not in default. What the landlord typically wants to see, and the landlord lender wants to see, is a statement that says that the tenant's lease is subordinate to the mortgage, so that it would be normally terminated in the event of a foreclosure, because by subordinating it, basically you're changing the dates. If the lease was signed in 2020 and the foreclosure takes place in 2021, then the loan was made in 2021, and let's say the foreclosure took place in 2022, then the lender would take the property subject to the tenant's rights, meaning they can't terminate the lease. The tenant gets to stay. As long as the tenant pays, they stay forever. In the absence of any agreement, if the lease was signed in 2020, the loan was done in 2021, and the foreclosure was in 2022, then if there is a subordination agreement, what that does is change those dates as if the mortgage was earlier in time than the lease. And in that case, first in time is first in right. And so if the lender forecloses, they would be able to terminate the lease. However, so the lease gets subordinated to the mortgage. The mortgagee likes that. However, they also agree and that in the event that there is a foreclosure, this is the non-disturbance part of the agreement. It's just like the simple non-disturbance agreement we just talked about. It also has a similar provision that says that so long as the tenant's not in default, even though the lease is subordinate to the mortgage, their lease will not be terminated in the event of a foreclosure, provided they're also not in default of the lease. And then you have exhibits like the legal description of the property, which is important if you're researching the title of the property, and certainly that would be a consideration if you purchase it. And many tenants, if they're making a long-term commitment, they do a title search on a property to make sure that the party that they're leasing from is actually the owner of the property. And so there's no restrictions on the use of the property and so forth. And then oftentimes there's a site plan of the entire property, if building or project, and also one of the premises. So those are your key lease provisions in an office lease. And I hope that you've learned something. Thank you for joining us for the Red Podcast. Invest wisely. See you next time.
Thanks for listening to the Real Estate Diversification Podcast. Did you enjoy the episode? Visit www.rediversification.com to tune in to more exciting episodes and free information and tools that will help you succeed. Leave us a review and subscribe to us on Apple Podcasts and our other social media channels at the RED Podcast. Thank you for listening, and we'll see you next time. Missouri Bar Advertising Disclosure. Neither the Supreme Court of Missouri nor the Missouri Bar reviews nor approves certifying organizations or specialist designations. The choice of a lawyer is an important decision and should not be based solely upon advertisements.